It's good to be with you again as we get ready for Lesson 4 of this year's 3 R's curriculum. As with all of the previous lessons, we start with a career counseling component. This time, instead of going back to the checklist, we're going to be talking with the students a little bit about the opportunity to be interviewed and give the students an opportunity to interview you as the volunteer. There's a list of suggested questions in the 3 R's materials that the students might ask you. Tell me a little bit about your job and your responsibilities there. Tell me about why you volunteer for the 3 R's program, or tell me about something that you've accomplished in your career that you're the most proud of. Obviously, if the students can come up with their own questions, that's great as well. Certainly, if they ask anything that's a little bit too personal, you don't need to feel any obligation to respond to that. But through this exercise, hopefully students will get a little bit of a flavor of what it's like to be in an interview and the appropriate ways to respond to interview questions.
The small group activity is going to be a discussion of the Fourth Amendment and search and seizure. And again, from past experience, we can tell you this is a lesson that generates a great deal of interest, and I hope you're ready for a lot of questions. The materials provided will give you answers to some of those questions, even if you don't practice criminal law. But students have, as I say, a great deal of interest in this because many have read or they've read about stops or they've been stopped themselves. So in terms of the substantive lesson, rather than have small hypotheticals on the Fourth Amendment, what we do is we start with those springboards that we talked about earlier. So we start with myth versus fact. Is it true that the police can search without a warrant? Or do they always have to have a warrant? Things of that nature. They will know the answers to those for sure by the end of the lesson because we will have talked about those. In small group, once again, we'll be focused on the substantive lesson. The substantive lesson this time is the Fourth Amendment, and it's a amendment. Search and seizure in the Fourth Amendment is something that's always a hot topic, always in the news, and the kids will have a great deal of interest and a lot of questions about it. So it has always proven to be a great lesson, and it will be again this time. We start with the myth versus fact springboard, which will generate even more interest. Then we begin to talk about the actual language of the First Amendment. What does it say? What does it not say? Then we present them with a search warrant. The Fourth Amendment does actually talk about a search warrant and what's required, probable cause, etc. We take a look at an actual search warrant. They take a look at a request for one to be issued, and they, in small group, play the role of a judge and decide, based on the facts and looking back at that language of the First Amendment, would they issue a search warrant? Why or why not? Is there enough probable cause or not? So that is how we begin the Fourth Amendment lesson. We then begin to talk about the exceptions to a search warrant requirement, and they will come to learn that the vast majority of searches in the United States today do not occur with a search warrant. It's important for them to understand that and all the exceptions to the search warrant requirement. The police stop you and they want to look in your trunk. Do they need a warrant? Do they have to ask for your permission? Do you have to give them permission? These are actually very practical situations that we'll be discussing with the students. So we'll then move on to talk about some of the very famous cases that are applicable to the Fourth Amendment. Many of them actually have a Cleveland connection. Terry versus Ohio, which was argued by Louis Stokes, a longtime congressman and great attorney here in Cleveland. And Mapp versus Ohio as well, that had to do with the exclusionary rule and what that rule means. What is the exclusionary rule and what is that all about? So those are the highlights of the things we'll be touching on when we talk about the Fourth Amendment.
And certainly it is true that this one does tend to generate a lot of student questions. And I'm a trust and estates attorney, so I don't know criminal law particularly well, but this is another good way to build credibility and relationship with the students. If they ask a question that you don't know the answer to, let them know you'll get back to them next month with that answer, and take some time to actually look up an answer for them. And if you come back the next month and have an answer for them, that's a great way to develop trust and relationship with them. Also, as they're asking questions, again, it's difficult to manage the clock sometimes, but remember to try to wrap things up in time for the Jeopardy review to reinforce those lessons.
One of the other things that I've mentioned, now that you talked about that, don't feel badly, again, if you don't practice criminal law. I don't either, and you don't know specifically the answer. You can tell them, you'll get back to them. But the other thing that's important for them to know, again, we've talked about common law, and even if we know what the answer is today, it might not be the same a year from now because courts are constantly reviewing these issues and changing. So we can give some general guidelines and principles, but it's important for them to know that it's all subject to change.
Yeah. And so this is a dynamic lesson that volunteers and students have enjoyed in many past years, and we hope you enjoy it as well.